Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In this episode of the Labour Justice Barometer, we'll be looking at the draft code of good practice on dismissals, significantly expanding on Schedule 8 of the Labour Relations Act. This draft code refines key aspects of procedural and substantive fairness in dismissals, covering misconduct, incapacity, retrenchments, and dismissals related to unprotected strikes. One of the most notable changes is its recognition of small businesses, allowing them greater flexibility in disciplinary procedures. Now, the draft code also raises new questions around fairness, consistency, and the burden of proof for employers in dismissal disputes. Legal experts have weighed in, highlighting both opportunities and challenges in balancing worker protection with employer flexibility. To unpack these changes and their impact on South African labour law, we're joined by Paul Benjamin, a leading labour law expert who has played a key role in shaping labour policy and legislation. Paul, it's great to have you on the Labour Justice Barometer. You've been instrumental in shaping South African labour law, from drafting legislation to advising on policy. So we're really eager to hear your take on the draft code of good practice on dismissals. Tell us about, first of all, your involvement, and if you can also tell us how you see this latest development fitting into the broader evolution of our labour law framework.
Thank you, Aisha and Debbie. Lovely to be on the podcast. And yes, let me first start off with my participation. The Code of Practice, which was published for public comment in January this year, is, as I think a number of people have commented, the first major change to the code since its initial publication together with the Act in 1995. And why it took so long is obviously an interesting story, but perhaps one for another day. The NEDLAC process started, I think, in late 2022, and there was a desire from the government side to update legislation, to bring the social partners on board with a range of changes that included both the LRA, the BCA, and the other laws, and also the unfair dismissal codes. That process initially moved slowly as it started during the lockdown and meetings were online. And in fact, it was only perhaps early 2024 that a decision was made that more progress would be made with in-person meetings. So NEDLAC reinstituted a process of the parties meeting in its Joburg offices. And there was a series of, I think, 8 meetings over the course of last year, which led both to agreements on a draft code to be published for comment and the amendments to the Labour Relations Act and the BCA, and a lesser extent, Employment Equity Act and the Minimum Wage Act, which have recently been submitted to the Minister and are now available for public scrutiny on the NEDLAC website.
Paul, thanks for that. And I think we should schedule a follow-up podcast to speak about the amendment bills. The goal of labour law development will always seek to balance employer flexibility and worker protection. Do you think that the draft code achieves this balance, or do you see areas where it might still need refinement? One of the developments in the code, obviously, is its treatment of small businesses and recognizing the constraints that small businesses operate under, and that they might adopt a less formal approach to discipline. It would just be interesting to get your views on the direction of the code, in particular in relation to small businesses, and whether you see any concerns in terms of balancing the rights of the parties.
Those are obviously important considerations, and they in fact have been part of the code since the inception. Initially, however, all the code said was that a less rigorous standard may apply to small businesses, and without perhaps saying quite what that standard was. There have been a number of factors that I think have affected the capacity of small businesses to conduct disciplinary processes. One has been concern that there was not that much consistency in decision-making, certainly in the early years among arbitrators, and therefore small employers were often advised to adopt relatively formal processes, often by labour law consultants who they were often paying significant sums of money to. And I think there was a concern expressed in a number of papers that perhaps these consultants were more serving their own interests than those of their clients in the advice they gave to small employers. Some time ago, there was the BUSA CCMA initiative, which sought to try and give greater guidance to small employers, and interesting studies which showed that small employers who get access to good quality free labour law advice are more likely to hire new employees than employers who don't have that facility available to them. So the code now, I think, really tries to say that what is the essence of the obligation during processes? It's also now reflected in the Act, and that is really to say that what an employer has to do in the disciplinary process is allow the employee a reasonable opportunity to respond to the allegations, and that doesn't have to take the form of a disciplinary inquiry. The case law is now sort of relatively settled, although it's only a a Labour court case, Avril Elizabeth, by Judge Van now of the LAC, but that has generally been followed, and I think it's given greater clarity. So certainly there's a sense that the field is now a lot clearer, although there aren't any recent studies of arbitrations. Commissioners are more consistent in their approach and not either imposing unrealistic requirements on small employers or sanctioning what are relatively minor disciplinary processes with large fines.
So just to follow up to what you've said there, Paul, just explain to us, what do you mean by small businesses?
The question of how you define a small business is an issue of great controversy. The one approach obviously is to have a threshold, and there's obviously always disagreement. The unions would say, small businesses, those with less than 5. Employers might say small businesses, those with less than 100 or 200 employees. And then one of the consequences of having a fixed number is obviously you get the anomalous situation where a business with 49 has to comply, but one with 51 employees doesn't. If 50 was so the code doesn't actually have a definition, because what is a small business will change. In the IT sector, for instance, you may have a very large business with a small number of employees with a very large turnover. So it's really, that's why the obligations of procedural fairness in particular are really of a sliding scale. You expect large employers, government agencies, to have very formal processes because of their complex managerial structures. Smaller businesses to have less formal processes, particularly those who don't have professional HR people. So it's really a question for the arbitrator to decide, in the light of this business's capacity and size, did it follow a fair approach? So it's done in that way. The code, initially we had 2 codes, one dealing with conduct and capacity, largely with conduct, which was obviously used extensively, and then a code dealing with retrenchment, which was adopted subsequently and which really just set out the wording of the Act, and really wasn't very widely referred to by the courts. There have been a number of key changes, both in the law and in the code, around dismissals for conduct and capacity. The first one is that for the first time, perhaps one of the key issues that in any country is, should there be some reduction of obligations on an employer during the first initial period of employment? And this is often what's referred to as a qualifying period, and there's a lot of economic argument that having a period in which there are less strenuous obligations during the start of employment encourages the hiring of new employees. And one of the related arguments is that, particularly with young workers entering the labour market for the first time, who may not have a CV or a work history, it's important to allow employers, almost as it were, to take risks, to hire people, and if it doesn't work out, to terminate. What the law now says is that the obligations in respect of procedural fairness and ordinary dismissal don't apply during the first 3 months. So in fact, there's now a 3-month qualifying period, as well as, and that reduced obligation would apply during a longer probationary period, which is both reasonable and operationally justifiable. So there is now greater certainty about the obligations during probation and an initial qualifying period. Those have to be read through a combination of the new statutory provision, proposed statutory provision, and the amended code. And what the courts have said, the Labour Appeal Court in particular, the court should not lightly interfere with an employer's standards for probation and its decisions around terminating during probationary periods if there hasn't been satisfactory performance, or in fact if it turns out that an employee may not be appropriate or compatible in a particular workforce.
So I think what I want to ask you, in terms of retrenchment, how do the retrenchment provisions compare to existing requirements? And does this draft code actually signal a shift in how retrenchments are being handled in South Africa?
I think, as I said earlier, the retrenchment code hasn't played much role. It hasn't had the central role that the misconduct code and incapacity code, or conduct and incapacity code, has had. As we know, we have 2 types of retrenchments: the sort of ordinary retrenchment, and then the large-scale retrenchments, where the so-called Section 189A process applies. What the code has sought to emphasize is that a simplification of process under Section 189, the ordinary retrenchments, and the requirements are set out in a way that would provide guidance particularly to small employers who may not be receiving legal advice during retrenchments. The requirements of Section 189, where a letter has to be written setting out the obligations or triggering the retrenchment process, remain the same. The process is flexible. Provided there's good faith, full reasons are provided. Retrenchment processes do not impose unreasonable obligations on employers acting in good faith. Where there are very substantial changes to the law has been around the Section 189, the so-called, the large-scale retrenchments, and this really applies particularly to larger firms, obviously, because it's only where at least I think 50 for employers above 50 in particular would qualify. In that case, the law, as it was introduced in 2002, allowed for a sort of a challenge to court during the retrenchment process, where the court would sort of intervene to try and sort out issues of procedural fairness, and procedural fairness would not be an issue in a subsequent unfair dismissal case. And bearing in mind that in this area, unions have the choice, of either challenging a retrenchment either as a dispute of interest and going on strike, or as a dispute of right and going to court. That sort of urgent interim process has been removed because it gave rise to a very complex body of litigation and a number of decisions going all the way to the Constitutional Court. And generally what was found out was that issues of procedure couldn't be resolved quickly by the courts. And therefore, we've returned to the sort of pre-2002 situation where after the retrenchment is concluded, the employer the unions, if they're unhappy, can bring a challenge both around the procedural and the substantive unfairness. So that's a significant change. It was one on which both Labour and business agreed in the end that and that will, I think, certainly for large employers and the large-scale retrenchments, simplify disputes. However, the whole process of facilitation, which is obviously quite important because it requires the involvement of the parties in a facilitated process prior to dismissals, remains. And one of the changes there is that the power to regulate those processes has been moved from the minister to the CCMA, so that the CCMA can appropriately update facilitation rules to make that process more effective. So those are really the major changes. I think the code will give greater clarity to all parties around their obligations. What is likely to happen is that the Labour Appeal Court will have to clarify those obligations in judgments as and when they arrive. I think that's one other point to make about the code is that there was a 28-year period between the code being developed and the present. And the code was meant to be a way of allowing union representatives, employers, officials, employer organization officials to be on top of the law and to deal with cases without the involvement of outside lawyers. Obviously, what happened was that the law got developed in a number of ways which weren't reflected in the code. For instance, there were a number of important decisions around ultimatums and strikes, the development by the Labour Court of the law around issues of incompatibility as a form of incapacity, and also incapacity in situations not particularly related to ill health, where the Labour Appeal Court had developed the law quite clearly. And so one of the effects of the code to incorporate that jurisprudence into the code. So the code is now reflecting the law as is, not the law as it was in 1995.
You're listening to the Labour Justice Barometer, and we'll be right back.
It seems the code has been updated with our jurisprudence on dismissals, both in a substantive and procedural sense, and aligns with our obligations in terms of ILO and global best practice. How do you envisage the code being implemented and the impact that it might have?
I think certainly the code will clarify the law. And for that reason, I think, particularly for those smaller employers without the expert HR or lawyers, it will make it easier to administer the law. One issue it doesn't address is perhaps the issue of how small employers should be provided with legal advice. And I think there are many countries where it's seen as a public good to have sort of non-profit consultancies that assist employers. That is something we don't have here. There's always that conflict between the content of the law and the practice. And as we all know, the CCMA, which is the primary labour dispute resolution organisation, has had an enormous caseload since the outset. That has meant at times certainly either very expedited processes or lengthy delays. And the second issue has been that, particularly for employees who succeed at the CCMA, that if their employer reviews then take up to 3.5 years in the Labour Court, and they're deprived of the benefits of their award for quite some time. So yes, there's always that difficulty between content and implementation. There's nothing particular in either the code or the amendments that addresses those issues. There was an attempt to make certain processes such as CONAR more readily available, but it's likely that both the CCMA and the Labour Court will remain under strain, and that may well have the consequence of delays in the resolution of matters continuing. The Labour Court, as we know, is under new leadership. There have been various procedures instituted to expedite it. More recently, there's the electronic case filing system. Hopefully that will allow, certainly, together with the new rules that were published for, certainly on the review side, those to be resolved more quickly and those not to serve to deprive employees of their rights.
So it seems that we will have to consider the draft code together with the amendment bills and the impact that might have, as well as other developments in future podcasts. So just for our listeners who may want to comment on the draft bill, the draft code, comments can be, we'll put a link in the narrative of the podcast for you, as the Department of Employment and Labour has invited comments within 40 days of publication. So there's still a month or so to comment.
The opportunity to comment on the code is a useful one, and those who are interested in the area should study the code and make their views felt. That will, the code process is likely to move quite quickly, and one can expect a final code to be in effect during or new code in the second half of this year. The legislative process, because it has to go to the Parliament, is likely to be much longer, and it's likely that changes to the law will only occur perhaps next year or even 2027.
Paul, thanks so much for joining us and sharing your insights on the process and the content of the code. Aisha, as always, it's been great unpacking these issues with you.
Thanks so much, Debbie, and thanks, Paul, and thank you to our listeners as well for tuning in. And just a reminder, as Debbie mentioned, that any comments may actually be submitted to the DOEL, and that is the Department of Employment and Labour. And you are welcome to let us know your thoughts in the comments on the draft code as well. So let's just keep this conversation going. And until next time.
Thank you.
This podcast is not intended to constitute legal advice.